Do you think India is ready for digital-only criminal trials, or would that destroy the very soul of justice? Welcome to the next hearing. Let's discuss criminal trials on video in India. What if criminal trials in India were conducted entirely via video conferencing? Police never enter the courtroom, evidence and testimonies happen remotely. Sounds efficient. But at what cost to justice? This isn't hypothetical. It's happening right now, and Delhi's lawyers are up in arms. In August 2025, the Lieutenant Governor of Delhi issued a notification declaring all 226 city police stations as designated venues for police personnel to testify in criminal trials via video conferencing without ever entering a courtroom. Lawyers across Delhi erupted in protest. The Division of Trial Court Bar Associations called a strike on August 22-23, warning that this move undermines fair trial and judicial transparency. The Delhi High Court Bar Association supported their dissent. Even the Supreme Court Bar Association did that. Lawyers donned black ribbons as a symbol of protest and publicly condemned the notification as unacceptable. As protests intensified, with sit-ins, effigy burning outside court complexes, and public campaigns, it demanded withdrawal, stating clearly that evidence can only be recorded in court in the physical presence of witness. A public interest litigation was also filed, challenging the constitutional validity of the LG's directive. Following assurances of dialogue with Union Home Minister, the strike was suspended, though the conflict is very much alive even today. Though the representatives had a meeting with the Home Minister, the government and police see video conferencing as a way to save money, reduce risk, and speed up trials. No more vans clogging Delhi's traffic, no more police officers wasting hours in court corridors, and yes, fewer adjournments. But efficiency is not the measure of justice. The Indian Constitution protects the accused not just from punishment without trial, but from unfair trials also. Let's break down why shifting police statements, evidence, and cross-examinations entirely online undermines fair trial. First, violation of open court and fair trial. Article 21 of the Indian Constitution guarantees the right to life and personal liberty, which includes the right to a fair trial. In Naresh Shridhar, Mirajkar versus State of Maharashtra, 1966, the Supreme Court stressed the importance of open courts where justice is visible to all. Video-only trial risks creating a closed, opaque process invisible to public scrutiny. Second, evidence must be in the presence of the accused. Section 273 of CrPC and the relevant section of the new BNS. The old Section 273 of CrPC requires that evidence be taken in the presence of the accused. The accused must have the right to observe witnesses directly, to understand their demeanor, and to consult with the lawyer in real time. A video link from a police station or office cannot replicate the solemnity of being physically present in front of the court. Cross-examination is weakened, as stated in Zahira Sheikh case. In Zahira Habibullah Sheikh versus State of Gujarat in 2004, the Supreme Court called cross-examination the most powerful weapon to test the truth of the testimony. On video, body language, nervous tics, and hesitation are often missed. Without the immediacy of a live courtroom, the lawyer's ability to break down falsehoods weakens. 4. Risk of coaching and influence. In the case of Sakshi versus Union of India 2004, the Supreme Court allowed limited video testimony in Sakshi versus Union of India, but only under strict safeguards. The court warned that witnesses must not be influenced or coached during testimony. In remote video setups, there is no guarantee that someone off camera isn't prompting the police officer or the witness. 5. Technology cannot decide liberty. In the case of Bandhua Mukti Morcha case versus Union of India 1984, the court held that procedure fairness is part of Article 21. If glitches, frozen screens, or distorted audio affect testimony, a person's liberty could hinge on a technical error. Justice cannot run on unreliable internet. 6. Delusion of judicial authority. State versus Charulata Joshi 1999 case. Courts derive their authority from presence. The solemnity of the judge, the witness standing in the dock, the gravity of the moment, As the court noted in State versus Charulata Joshi, the dignity of judicial proceedings must be preserved. A video screen reduces this dignity to a casual call. When weakening the accused's right to defense, in Kartar Singh versus State of Punjab, 1994, the court emphasized that the accused must have full opportunity to defend. On video, consulting privately with one's lawyers becomes harder. Confidential communication is at risk. The accused becomes a passive observer rather than an active participant. In sum, Article 21, Old Section 273 of CrPC and Supreme Court precedent all point to one truth: criminal trials cannot be reduced to more video calls without gravely endangering justice. The government sees efficiency, the police sees relief, but the Constitution sees something else. The accused's right to confront their accusers, to cross-examine freely, to be tried openly, and to defend themselves fully. Yes, technology has a role in courts for routine hearings, for scheduling, even during emergency like COVID. But when it comes to police statements, evidence, cross-examination and accused statements, video conferencing should never replace the sanctity of the courtroom, because justice must not only be done, it must be seen to be done in the open light of a court of law, not hidden behind a flickering screen. Do you think India is ready for digital-only criminal trials, or would that destroy the very soul of justice? Tell me in the comments, and don't forget to like, share and subscribe for more deep dives into law and justice in India. Thank you. This is Amol Viduri and we are watching the next hearing. Thank you.